Good morning and afternoon, rather. Thank you for joining us for this very first session of the ACC South Carolina Chapter virtual annual meeting. We are excited that you joined us today, and we're looking forward to you joining us in the upcoming seminars as well. Be sure to register for those. With that being said, I'm going to pass along for some introductions and submit all Q&As in that Q&As feature of Zoom, and we'll be sure to answer those questions.
Okay. Hi, everyone. Good afternoon. My name is Angela Strickland. I am a partner at Bowman & Brook in Columbia, South Carolina. I practice primarily in product liability defense, mostly automotive defense, and some other products, some industrial, little medical device, but sort of my primary focus is automotive. I'm here today with Kevin Malloy. He is exactly 6 feet to my left. He will be introducing himself a little bit later when I hand over the baton to him to do the later half of the presentation. He is my partner here at Bowman & Brook as well. Just so you guys know, your cameras are off and your microphones are off. So I am speaking into a camera, not seeing your faces as would be with a normal presentation. So that's a little bit different and interesting to get used to. But I will do my best to try to look straight ahead and keep you guys engaged. We're here to talk to you about data footprint. So a lot of this discussion is going to be, everything is changing with, since the pandemic, COVID, that sort of thing. We are pretty much all working in some sort of a virtual environment at this point. We have all been putting data out there for years now, really, with smartphones and different types of devices, but even more so, that is how we are connecting to each other just to do our everyday work. This presentation will focus on both data that your employees may be putting out there in the world. This also will relate to data that can be used for risk management in litigation, data that you could find out about that a plaintiff may have, for example. There will also be some discussion of how your company can use data for other types of purposes, advertising, sort of getting your brand out there and that sort of thing. And then of course we'll talk about just some of the liability implications as it relates to all of this data that we are putting into the world. So first, I'm going to talk about wearable technology. Wearable technology really is just a term for any type of device that a user would wear that transmits, collects and then transmits information over the internet. It would be information that can be transmitted really to two main places. One would be, usually it would go through your smartphone or your computer or whatever you're tethered to. And that information would then be sent to the cloud, for example, with Apple products. It would be also sent to third-party developers in the case of if you were using an app to collect that data. And that data gets not only collected, but it gets analyzed and it gets stored. And it gets analyzed really for two purposes. It gets analyzed first for the user, right? So in most instances, someone is choosing to wear this technology. So for example, I have my iWatch, my Apple Watch. I have been wearing one for, 3 or 4 years now. I love it personally. They say right now, 1 in 6 people are using some sort of wearable technology. I am the one. Kevin is one of the other 5. I know he doesn't care much for the wearable technology, but I'm a big fan. It uses hardware sensors that monitor things like my heart rate, for example. It monitors my sleep pattern if I choose to wear it while I sleep. It gathers all sorts of biometric information. It also can gather location data and that sort of thing. And then, of course, it's transmitting that information back through my phone and sending it on to, both the developer of the product and also, again, any third-party application developers that I might be using their apps integrated on the product. Just a little history about some of the wearable technology. One of the first attempts at this, a smartwatch, was this 1984 Seiko that you can see here on the slide. This was really just more like a wrist calculator. It obviously wasn't checking your heart rate or doing anything like that, but it did a little more and could collect information that when you used it on your watch, that you could then connect it back to this device, this sort of dock station, and it could actually have a little printer attached and it could read out information. So I guess if you were going through your day and I don't know, had some mathematical equation you wanted to remember later, you could type it in and then plug it up to this dock later and use it that way. And then things obviously got more advanced with the idea of wearable technology, and you started seeing the Fitbits. 2009 Fitbit, again, I love the technology. I had a Fitbit pretty early on. I believe that first one didn't do a whole lot. It measured your steps every day. But that was, you know, kind of the entry into what we really do see today. And now, you know, you're at the situation where you have, for example, the Apple Watch. On the slide before, you know, there were a few more products on there that are kind of interesting and worth mention. There's a smart ring, for example, and as I was doing some research for this, came across an article where NBA players are currently, certain teams are wearing, it's just a band that you would just wear, you know, on your ring finger, and it's collecting not only, you know, your heart rate, your respiratory functions, it's getting your temperature, which the Apple Watch does not do. And so it's collecting your temperature as well. And the reason that these players are using it, because they are trying to find early signs of COVID. So if you have this ring, it will actually measure several of the things that can give you an early indication of potential symptoms for COVID. And that information is actually being transmitted to their coaches and their trainers, and they're using it in that way. Some other sports have used some of the wearable technology that you can find in the clothing items, the shirts, that sort of thing. And those can actually have the hardware sensors embedded within the shirt that can then take some of those athletic measurements. And you're seeing some of those used in college and pro athletics. I mentioned to Kevin the other day that on that list was smart pants. And his comment back to me was, I don't really want to know what smart pants does, but I had to look it up and see exactly what smart pants did. And smart pants are actually yoga pants that help you with your yoga practice by telling you when your posture is not good, or when your back is not straight, or your legs are not straight in a certain pose. So they're $250. They are machine washable, but that's what smart pants are. So lots of different types of devices. Some of the functionality, you know, I've kind of talked a little bit about this already, but, you know, there's hardware and software. The hardware, you can see this picture here that has the little, sort of shows the little sensors that are on the bottom of an Apple Watch. Those sensors, I'll notice mine kind of light up under there sometimes when it's reading certain things. It also can give you some sensation back, these little sort of haptic taps. It can give you whenever it's checking your heart rate or checking whatever. It can also let you know things unrelated to your health, such as if you got a message on your phone, it dings here and gives you a little tap and lets you know. And then software, you know, OS operating systems, that's just a platform that allows these systems to work together. Some of the technology, such as the shirts and the pants, those will have sensors but won't necessarily have OS platforms involved there. Those will really be more, they'll have the ability to Bluetooth to your phone, and they're really just sort of a one-way sensing where they are sending you back, sending the data back to your phone to try to help you with whatever you are using that for. In those cases, it's usually going to be something athletic related or health related. Your watch, on the other hand, actually has OS system or operating systems embedded in the watch itself. And so those allow for apps to be downloaded onto the watch, as well as to allow it to synchronize with your phone in order to communicate back and forth. And this is just a little more about just the background on platforms. You know, the biggest thing is it allows not only the manufacturer of the product, but also third-party app developers to access that data and to use that data. And not all of us read the fine print whenever we download an app or whenever we buy a product, and there's a lot of it on some of these. But in every instance, you're agreeing to end user permissions basically to give this information on. And really the functionality wouldn't work if you don't do that, because it does need to go back and be analyzed in order for the user to use it. I mean, just your heart rate, you can see that, and that gives you one piece of information. But if you've downloaded an app, for example, to help you get from your 10-minute mile to your 8-minute mile, they're going to need to analyze a lot more than just your heart rate and put that all together to sort of help you to improve whatever it is you're looking to improve. This slide just shows sort of the data flow that happens. There's sort of the two main types of systems, the proprietary system, which again relates to the developer of the actual product, the actual device. They are going to be getting that information. Again, usually that is going to be sent up to the cloud. They're going to be getting it that way. And then you've got the data will also be going to the third parties as well, going to their systems. Okay, so we have a whole slide on the Apple Watch, which, you know, kind of been using that as my example because it's a pretty easy one to explain, and as well as me having experience with it. But again, that Apple Watch, you actually download apps directly to it. And so you're able to work through those apps directly on the watch itself, but then also through the phone, and it is constantly collecting and storing that data. And it also, you know, will have the updates from time to time, just like your phone does. So it also has to be updated to make sure that the operating system on the actual watch is staying up to date like it needs to be. One of the big ways that you see these products used, again, is through a health type of function. The Apple Health platform is actually really pretty interesting stuff. You know, there's a complete health app that comes on your phone, and you can enable it to do lots of things. Some of it, you just put some of your basic emergency contact, any dietary restrictions, any allergies, blood type, that sort of thing can be put into your phone, and that can actually be accessed without your code in emergency situations. So that can be used if you were to get in some accident and you were not conscious, then a doctor could use that and could access that. So that's one way that this health kit on your Apple products work. The other way is just this data that we talked about. So the heart rate, that sort of information. A very interesting development that happened, gosh, I think this came out maybe in May, or at least it was being beta tested back in May, was the ability to do contact tracing for COVID through the use of your Apple Health app in your phone. So you had to go in and turn it on, but in one of the latest updates, you could go in and turn on this feature that would allow the contact tracing. So basically, person A would turn it on their phone. Person B would turn it on their phone. If person A and B were sitting on a park bench, you know, yesterday, and sat there for an hour, didn't even speak to each other, didn't even know each other, well, their phones are talking to each other. Their phones are keeping track of where they are and where they are in proximity to others. So while it's doing that, if person A goes and tests positive for COVID today, they can go back into their app, they can actually mark that they tested positive, and then it will then send a text message to all of those phones. It won't tell that person anything about anybody else, but it will send messages to all of these different users to say, hey, at this time, at this place, on this date, you were next in the proximity of someone who has tested positive for COVID. So it's a way to contact trace. It is not forced on you. That is something you have to turn on. I personally don't have mine turned on. I think it's fascinating, but kind of waiting to see how that plays out a little more before I'm willing to be quite that connected. So anyway, that's another way that this data and this wearable technology is being used really in a very up-to-date way. There are lots of legal questions posed related to this information. HIPAA is one that comes to mind pretty quickly. You know, privacy, security, access, who owns this data. HIPAA, for example, it is not a HIPAA, there doesn't have to be a HIPAA permission given in order to get this data in litigation, for example, because Apple is not one of the protected entities that is required to give or not give information under HIPAA. So if someone sends a subpoena to an individual for their Apple Watch data or to the third-party administrator of the app for data, then it's not, HIPAA doesn't have to be followed in that instance. As far as privacy and security, I think we all have seen in the news many times, this is supposed to be kept private. Whenever you share information with an app, especially health information, you can actually go in and choose which type of information goes and what doesn't. Whether that's strictly followed, I don't think any of us have the expertise to know exactly what is being transmitted and what isn't. I think, we just have to expect that if we are putting this information out into the world, it is out there in the world and it's going to be accessed in some way or another. There can be arguments made about authenticity of the information, reliability of the information, that sort of thing. But I think we are going to just have to expect that it's out there. And I would think, under Federal Rule Civil Procedure 34, this is absolutely the kind of information that should be discoverable, that's in somebody's possession, that, it would still have to be, for evidence purposes. Is it, authentic? Is it reliable? Is it relevant? All those questions would still have to be answered, but could it lead to to discoverable information? Then yeah, I think so. So again, that's going to be information that you'll want to try to seek depending on what kind of case you might be dealing with. There's been some litigation involving wearable tech. I mean, these were just some of the very first cases. I expect that we will see a lot more. There was a fabricated sexual assault report that occurred, and through the use of Fitbit, we're able to figure out that the individual was not actually asleep and attacked, but had actually been in a slightly different location, had been up, that sort of thing. So they were able to reveal that that information that she gave verbally was not accurate to what, at least what the Fitbit data showed. There was a case in Canada where a personal trainer had been injured 4 years before and used her Fitbit over the subsequent years since her injury to then be the data to be analyzed to show this is not what we would expect to see from the health and fitness of someone her age, showing just how debilitating the injury had been to her as a once personal trainer and very fit individual, to show the difference in that standard. So that was something that was being used by the plaintiffs in a personal injury case. And obviously you could see how a defendant could use it by collecting this information and, either showing, like in what I do with automotive products, could potentially show that there was an irregular heart rate, that something was going on medically right before an accident. So maybe the accident was actually caused by a health condition, that sort of thing. Or just if somebody has been injured, or workers' comp, for example, any of those types of things, if they're using wearable technology such as an Apple Watch and you get that data and show, wow, they said they couldn't, go on their runs they enjoyed anymore, and yet here they are running this many miles every day. So it's that kind of thing. It kind of can cut out a private detective a little bit in some instances in litigation. Social distancing wearables, we're starting to see where some companies are using wearables to sort of enforce social distancing. Ford was testing out the use of basically a type of watch type of device that would vibrate or make a noise whenever their employees got within 6 feet of each other. So if you think about an on-site factory warehouse kind of situation, then that could be somewhere where something like that could be very useful. It also could be used for, again, like a workers' comp situation. There was also some really interesting wearables where rather than a watch, it would be almost like a walkie-talkie type of thing, and it could measure not only stuff related to where the employee was, but it could sense a gas leak in certain types of facilities, or if that individual was working and was injured or fell, then it would be something that could, alert the employer to that individual. Last thing on this section, these are just a couple of examples of discovery related to wearable devices and wearable data. A couple of interrogatories, obviously, do you have any? Are you using any? Tell us what you're using. Have you preserved it? Have you backed up your iPhone or your Apple Watch, that sort of thing? And then obviously requests for production where you can actually ask for that data. Those are just a few examples of how to get this data in litigation. I'm now going to move to social media monitoring. This is, again, just it's another form of monitoring. This is more information, a little bit of the wearable monitoring is involuntary. I mean, you chose to wear the wearable, but the information that's being gathered is something that it is just reading from your body versus something you can control. Well, social media, on the other hand, is absolutely should be within your control. And so we're going to talk a little bit about employers monitoring social media for advertising, marketing type purposes, and also just to make sure that your employees are not doing and saying things related to their work that could, expose liability. Basically, social media monitoring is just the process of surveilling different social media platforms. It doesn't have to be social media, it could be blogs and personal websites, but most people do those types of things now through social media. And what you're looking for is stuff related to a particular brand, company, industry, that sort of thing. The tools are based on algorithms that basically just crawl across all of these different platforms and are just looking for keywords, looking for tags, looking for hashtags, all that sorts of things, and just gathering that information. There's also the idea of sort of social listening, which is, as opposed to monitoring and kind of looking at what's already out there, it's more of an anticipating and looking forward and trying to, build a strategy around what you've seen previously to sort of what you think is going to appeal sort of going forward in the future. There's lots of different sources. I mentioned, blogs, things like that. It says here publicly available social networks. Twitter is very public, so if stuff goes on Twitter, everyone's going to see it. But Facebook, Instagram, TikTok, those type can be set to private. Now, of course, you have friends on Facebook and you have people you follow and who follow you on Instagram. So there are still people who are going to see your information, and I mean, they can just screenshot it and send it wherever they want to. But as a company, if you're not friends with someone on Facebook, which you probably won't be as a company necessarily, they'll just follow your page. You'll only be able to see what they have marked as public and what they have in their public settings, and do it that way. So my Apple Watch just started ringing me in the middle of this, so that tells you how these things work. But as it relates to the social networks and what you can see, there's some really interesting information to be had out there. Some of the type of data that's recorded is mentions is one of the things that can be monitored. So if your company is mentioned by anybody, whether it's positive or negative, that can be monitored. The interesting thing with mentions is you'll see a lot of people engage companies on Twitter especially. So Twitter, I follow like Wendy's account, for example. They're one of the funniest ones out there. They do a great job of people will say, hey, Wendy's, if you retweet me in the next 5 minutes, I'll go buy one of everything on your menu. And then they'll retweet them. They'll go buy all the stuff, take a big picture. It just gets people engaged. It's funny. It's, just a way to sort of have what feels like to people very personal customer contact. But you can use some of these platforms and some of these companies to monitor that for you, look for mentions, whether they're positive or negative. Also, they'll look for shares. If you post an ad, if your company's page, your Twitter page or whatever it is, a Twitter account, posts something, who's sharing it, and you can sort of, start following those people and seeing what their habits are and what they say about your company. Likes, people can give you a thumbs up. You see, the number of likes that are out there, and then in videos and stories, whether people are posting things about your company and tagging you in them and that sort of thing. So how does that happen? This is an example. This is Hootsuite. This is what the dashboard looks like for them. You can set as a company things that you want to monitor. So keywords, hashtags, certain locations, specific users. If you see someone who is really, sort of becoming a brand ambassador for you, which can happen very organically a lot of times on some of these pages. I've seen some really interesting things with influencers on Instagram, for example. They'll just like Target and they'll use Target's products to redecorate their living room, and the next thing you know, they have partnered with Target, and they'll make a little video, and they partnered with them, and Target has provided them with everything to redecorate their back deck. And so they will put everything on there, link it to all the things, and if you like that, what that person's decorating choices, you can go on there and absolutely just go buy it all. So with Hootsuite, you can monitor all of that. You can look for the users, you can look for all of that, and once it's set up, you can then have your different departments access this, or you can send things for attention to different things. So, your litigation department could be looking for, or your legal department could be looking for, any potential issues if somebody says they were hurt on your product or something like that. That can be an early monitoring of that. If it's something positive, that could be something that, could be worked on to hopefully, just that person will continue to sort of spread goodwill about your name. That sort of thing. And it's just to provide customer service as well. Yeah, so just like I was saying, some of the really good capabilities is to be able to engage with your customers, to manage a crisis. So if you find yourself in a crisis, obviously, first thing you want to do is to figure out what you want to say with your PR folks. But once you have it, something like Twitter is the quickest way across a huge platform to get the word out about whatever you want to say to try to address a PR issue. You can track your competitors. You can track any pain points related to your product, anything negative. You can also, like I mentioned, identify influencers and advocates. And like I said, the customer issue is really interesting because you can address customer service issues, and I see them addressed much faster on Twitter than anything else. I had an issue back in the spring when COVID kind of blew up. I was supposed to go to England. I had to cancel my flight with Virgin Airlines. I was, like I said, going to the UK, and couldn't get through by email, couldn't get through by phone, couldn't do anything. Well, I decided to tweet at them, and when I did, I got a response immediately that said, we will respond in the next 12 hours. And they responded, canceled my tickets, everything. And you will see that all the time with real-time customer service occurring across these platforms. And I can tell you, when I see a company address something like that in a really good way, it makes me want to do business with that company. So that's a really good way that you can go through that. Some potential risks, some of this relates to really advertising type guidelines and compliance, but as a company, you definitely want to watch out for some potential risks related to what you share or decide to retweet. If somebody is giving you a testimonial that you can't prove is accurate, you want to just be really careful about endorsing that. Also, for the next one, endorsing third-party content. You just want to be just really careful thinking about whether you're violating anything related to advertising or false advertising of some sort. Likes are probably okay. So if somebody posts something positive and you like that, the company's page likes that, okay. Employee commentary, that's something you definitely want to educate employees on. Whether it's something positive or negative, if an employee is saying something about the company or the product, can that be used against the company later? If it's from the employee's individual social media page or whatever it is, then probably not. It's probably, as long as you're able to show that the company did not entice them to do it, or it's not controlled, the page is not controlled by the company, then it's probably going to be okay. But those are just some of the risks that you want to watch out for as it relates to all the social media monitoring and and the capabilities there. So I am now going to trade seats with Kevin. He's going to introduce himself, and he's going to move on to the second part of the presentation. And it's been very nice to speak with everyone today. If you have questions, just continue to put them in the chat as they occur to you, and we're going to address those in the last few minutes of the presentation. Thank you very much.
Okay, good afternoon, everybody. Thanks for allowing us to speak with you here today virtually. And as Angela mentioned, I'm a partner here at Bowman and Brook with her. And like Angela, I'm primarily focused on the defense of product liability cases, but not exclusively. Although compared to her, I'm a real Luddite when it comes to a lot of the social media, wearable technology, and all of that. I just frankly makes me a little uncomfortable, but since this is the world that we live in, I felt it would make sense to learn how a lot of these things work, and of course make sure that we're all doing the right things for our clients and when we're dealing with these new tools and the data that's out there. And so I'd like to pick up with a few more thoughts on social media, more practical considerations when you are facing a lawsuit, and really the discovery side of that lawsuit. The first question is, who owns the data? Where is it? Let's say you get an RFP that asks for your company's social media postings. Well, if you've interacted with the platform, you should be able to collect that data directly from the platform. But of course, platforms change, the way they're used can change. And so a wise plaintiff would subpoena the platform itself, because those platforms do store essentially everything, like we've kind of talked about. Their whole reason for existing in some ways is to collect, analyze, store, and sell this data. So sometimes you won't be able to get the information that has been requested of you in discovery, and that is fairly, or at least arguably, discoverable. One thing to keep in mind, though, is if your company is using a vendor to interact with social media on your behalf, perhaps they're monitoring potential customers or people who are sending messages or interacting with your business, chances are the data that vendor possesses in relation to its role on your company's behalf will be discoverable, even if you don't literally own it or hold it. Most courts will agree that information that's in your custody or control is discoverable, and usually that would be considered in your control. So something to think about, at least as a second level of discovery if you have a persistent plaintiff's lawyer. Couple thoughts. This might not apply to everybody, but I think it'll cue you into some things to think about. These are things we've encountered in our experience as product liability defense lawyers. Certainly communications between the defendant and the plaintiff are likely to be discoverable. But the bigger concern, and the one that sort of lurks in the background, is the potential for a company to have allegedly been put on notice of a danger or defect or problem with their product. The same idea could happen in non-product liability contexts, where we have these intentional, willful, reckless, wanton, this standards that can trigger the risk for punitive damages or be the standard of liability for certain causes of action. So what I'm thinking about is perhaps there's a customer complaint made through social media or simply through a message board sometimes for enthusiasts of a certain product, where they say XYZ happened or didn't happen, and this problem occurred, or this thing that the device was supposed to do didn't do that. And so what I'm thinking of here, I spent a year as a in-house lawyer for General Motors. I was loaned out by my firm, and it had a sort of customer services department that would interact with people online who had complaints about products. And sometimes enterprising plaintiffs' lawyers would suggest or argue that those interactions did or should have put the company on notice of a defect with the product. And then invariably, the types of interactions we're talking about were discussing different issues than what was involved in the underlying case, but it was discoverable information, and it did in some instances create challenges with the defense. So, so you want to be very mindful if you're having people in your company interact with customers on behalf of the organization, especially but not exclusively if the types of things they're interacting with customers might involve potential safety issues, or to make sure that they're well trained with how they communicate with the customers and how they internally report and share the information obtained from the field in that way. And you want to be sure to preserve all of that, because chances are it will be discoverable in the future. Okay, a couple examples of the sorts of discovery requests that could be sent to the plaintiff in a case. These are very similar to the examples Angela gave with the wearable devices, but you want to first find out what social media platforms your opponent uses, and then of course you want to find out, if you can, the relevant timeframes they've used each platform, and then ask for copies of their posts and postings. And never a bad idea to take a look and see if things like that are publicly available even before you're involved in formal discovery. But keep in mind that if you do that and collect that, chances are what you collected will be discoverable in return. Okay, so let's switch gears to cell phones. This is something we all know quite a bit about, probably, and at least have a sense for just the depth of data that is generated by cell phones. We're mostly going to be focused on location and identification data. That's pretty simple. It's literally information about where a device, it didn't have to be a cell phone, it could be an iPad or one of the wearable devices Angela talked about, but primarily we're thinking about cell phones here. Just literally where that device is and when it's in those places. That can be very useful information for marketers. It can be useful information for keeping track of employees who work off-site. There's a variety of uses for it. Some of it is obviously beneficial to a business, helps you target your marketing, but then you can understand why some individuals can be a little nervous about the thought that where they are at all times is being collected and sold to others for their use. And probably we all feel some of that on both sides. Anyhow, all sorts of sources of information, types of information that's collected. The one we're probably the most familiar with is GPS, global positioning systems. We use these, for example, in our traffic apps, or to help us find the best route. If you're driving from here to somewhere you haven't been before, your device is in constant communication with a network of satellites, and it pretty accurately will tell you where you are at any given time. And this can be updating on a very regular basis, and so accurate that you can get an accurate sense for how fast someone is traveling, for example. That's why when you're looking at your Google Maps app, when you're driving on the highway, you pass the exit on the app at essentially the same time you pass it in real life. Another one that we're probably at least vaguely familiar with are ISPs, Internet Service Providers. And those are, your ISP is kind of like a thumbprint, a fingerprint for your device. And when it connects to the internet, it transmits information about where your device is when it connects. And this will happen at your home, your router, and that information about when you connected or when someone else connected to your network will be shared with and stored by your internet service provider, and that will keep track of who's using the internet on your network and where. Sometimes though, and this is especially important with cell phones, since most of them are constantly connected to the internet, it's another way to track your location, because your cell phone is communicating with the various cell towers that provide internet service in much the same way your laptop would communicate with a router to provide your laptop with Wi-Fi. So as you move about, this is another way to accurately determine where you are. And it's happening passively, even if you're not literally using the internet app on your phone is staying connected, so it's happening all the time. Other ones are social media apps, and really that's not an accurate description. I'll just say apps. Sometimes these are games on your phone, or if you want a little thing that turns your face into a cat or something like that. Chances are, if it's a free app, you are the product. You get to play the game or make the funny picture, and they get to find out where you are all the time. There's a lot of other types and ways information like that is transmitted. You can see a list of them here. Those are some of the big ones. But the point is, why do this? It's not just to record where you are. It's to process that information and do something that is useful to somebody with that. And obviously, we've sort of touched on them. There's targeted marketing, things like that we'll talk about in a little more detail. But one thing I'll mention before moving to that is each of our mobile devices have what's generically described as a mobile ad ID. This is different than your ISP, but it's similar in that it's alphanumeric code. It's like a serial number or a fingerprint, and this is keep track of where you are at all times, and it's provided. That information is collected by your cell service provider, and it's used more or less exclusively for what ads will be targeted to you through the various apps that are built into your cell phone, or that your hardware, Apple or Samsung or whoever, the hardware manufacturer chooses to sell with third parties. And these can be really useful and a little scary too, because they're often cross-referenced with other unique mobile ad IDs, and that enables a company or companies to figure out not only kind of who you are and what you like, but who you spend your time with and what they like. And even if your name is not literally attached to it, before you know it, a massive amount of information is collected through these mobile ad IDs. And again, all that is ultimately used to analyze the data. And there's essentially three types of organizations that analyze the data. The first is the hardware vendor itself, Apple, Samsung, whoever might have made the device. And they use that to target ads, as well as provide other information that they'll use to maybe develop new apps or things that might make their product more exciting for the future, keep their market share or help it grow. They'll also often sell that information to third-party app developers, who in turn might sell it many times over. And then websites themselves. So websites will collect information about what you were looking at and what you were searching for, especially if you were on a shopping site or something. I'm sure we've all seen ads that relate to things we were recently Googling or shopping for. So that's the primary use, as far as I'm aware, of primary commercial use of all this cell phone data. One more thing to think about before we transition a little bit is in Apple devices, most of the apps, maybe perhaps all of them now, you can individually select whether you're sharing information generated by and through that app or not. I am a skeptic about whether or not any of those things can ever truly be turned off, but in any event, you do have that option. Samsung, my understanding, I don't use a Droid, is that it's a one switch only. You either choose to share or not share. And then when you make that choice to share, again, you get the benefits of things like up to the minute traffic updates. You get to find out what stores are nearby that theoretically are selling things that you would be interested in. And also the cell providers and the third-party apps sometimes are figuring out what sort of places are important to you. If you always go to the same coffee spot on Thursday morning, or you always stay at the same hotel when you visit a city, or whatever it might be, things that are important about you that they then use to ordinarily target more ads at you. How precise is it? We've kind of talked about it, except for this one detail that's a little scary. Is a couple years ago, the New York Times published a study that looked at the location data that was generated, and it found that some people, due to the combination of apps they had on their phone, were generating as many as 14,000 individualized data points per hour about their location. Something to think about, though, if you're interested in utilizing this data, is in addition to the really potentially overwhelming amount of individualized data, there are data brokers who sell aggregate location data, which kind of collects and processes a lot of information about an individual, but it's a little more generalized. You might see how many times they go to this type of place in a week, or how many times they travel to this geographically bounded location in a week, or something like that. Okay, so let's get to some other uses of this data in the commercial context. I'll kind of take these in reverse order. Angela touched on some of the wearable devices that are coming out now. Amazon recently patented some wristbands for its warehouse employees. And the idea is they use information, primarily radio frequencies, which is a source of location information I didn't mention, but essentially a radio frequency transmitter can be embedded very cheaply in an item, and it will detect when a device that's capable of receiving that frequency, and your cell phone would be such a device, is close to it. So Amazon has put that technology into wristbands, and the goal is to make it much more difficult, and one day perhaps impossible, to misstock something in a factory. The user will get a little vibration if they're at risk of moving their left hand, let's say, which is holding the radio frequency enabled item. It'd be in the little barcode, and it's about to go in the wrong storage bin in the warehouse. So that's still a developing technology, but it's something to think about. You can really see how it would be useful if you are, have a big retail operation, or warehousing operation, really more accurately. But the larger point, though, is how do employers use GPS data and other location data, and what are some of the legal things they should be aware of? The reason you might want to do it is pretty obvious. If you have off-site employees, or employees who are supposed to make service calls at certain locations at certain times, or who are if it was a vehicle, for example, a company provided vehicle that had certain restrictions on how it's used, you can think of a number of useful and perfectly legitimate reasons to track that. And the bottom line is the legal landscape is pretty much unsettled right now, although it is, in a broad stroke, pretty favorable, it would seem, to employers. There's no federal privacy law right now that prohibits employers from using GPS data to track their employees. However, there are a number of states that have statutes prohibiting anyone, not just an employer, from using a vehicle tracking information, from tracking a vehicle without the vehicle owner's consent or the vehicle user's consent. California is probably the broadest one. It has a similar statute to that I just described, but it's not just a vehicle, it's, quote, any movable thing. And clearly that would apply to a cell phone. There are restrictions on how that can be used to track people. But in most other places, it's pretty wide open. Although there have been a few lawsuits that have started to come across. Unfortunately, for our purposes here, most of them end up settling, and usually with confidentiality provisions. So we don't get a great sense for how these types of cases might go. And of course, we don't get much case law out of them. But one of them is a case called Arias. This was, shoot, I'm blanking on it. I believe it was in California, but I can follow up. But anyhow, a former employee sued her former employer on the grounds that she had been terminated because she disabled a GPS location tracking feature of an app her company required that she have on her phone. She argued that she was being tracked even when she was off hours, and that she should have a right to not do that. And as mentioned, the case settled, and it settled for a confidential term, so we don't know exactly where that was going. But the arguments generally are going to boil down to some pretty basic things. First, fundamental thing to remember is we like to talk about our right to privacy in this country, and that comes from the Fourth Amendment, which of course restricts what the government can do. So it doesn't really directly apply to private entities. So then you start to get into, in some ways even more fundamental things. Who owns the device that is used to track is usually an important consideration, it seems. And what did the person being tracked consent to? So the obvious teaching point, of course, is make sure that you make your employees aware if you choose to use this type of information that you're going to collect it and use it. There's been a few other class actions, all in California, or primarily in California, various variations of collections of plaintiffs saying that it was improper for companies to have collected so much data for them. And these have more or less been dismissed outright as failing to state a claim, or for a judgment on the pleadings on the basis that they had consented to that tracking. Some of them have settled those. So I think a good takeaway is, if you are going to track data for your employees, track the least amount necessary for the business need, and make sure there is a legitimate business need, the least amount of data to accomplish that need, and disclose it to the employees up front. And it seems to be, if you do things like that, you'll be pretty well protected in the event of litigation on that topic. This is something we kind of already talked about. I should say the where is it stored and who owns it. I'll give you another example. This is just a reminder about the automatic Wi-Fi logon and how it's useful for tracking people. As the slide indicates, some high school seniors were doing the senior prank thing. They were going to cause some trouble after hours at their high school, and they were careful. They knew about cameras and they hid their faces, but they got busted because their phones were set to automatically log on to Wi-Fi that they had previously logged on to. Of course, they had, because that was their school. So the lesson, of course, is if you're going to vandalize a high school, make sure you turn off your Wi-Fi login if you want to get away with it. But more significantly and more importantly, and this is kind of changing subjects drastically, is there was a recent study that showed that all of the cell phone providers, or the big ones, are selling data to the same data broker. And in theory, that data broker keeps this information secure, but a security specialist at Carnegie Mellon was able to access that database and more or less track every cell phone user's location in real time with pretty darn accuracy, pretty darn good accuracy. So you can see again how that would be useful to you, how it's a little scary as an individual, but keep in mind that that's out there. This is similar to, this is another quick discovery case study, again focused on product liability, but still useful for other people. Just a series of example questions you'd want to ask to figure out what data might be out there to collect, so then you could target your second level discovery on those the places that would have the data. I'm running low on time, so I'll kind of skip through that to very briefly touch on a different topic altogether, and that's the way the new COVID world is affecting some of the things we've been talking about. So a lot of people, certainly in the white collar side of things, have been or are continuing to work from home. And some of you, they might be using their personal laptops or computers. Perhaps they're provided by the employer, but they're almost invariably going to be using their own private networks, which in most individuals' cases are not going to be as secure as a network in the workplace. So it's something to think about when you're, as you assess what confidential information that's important to your organization your employees have on their computers that they're working from home from. Unfortunately, I don't have a great solution for that. It's one of the many trade-offs since we're dealing with this pandemic, but it's something to be aware of. Another important thing to think about is perhaps you have automated systems that back up your employees' email and things like that, and make sure that information is stored for your business's use and for any future litigation. But if you have instant message type apps where your employees can communicate with one another through means other than email or phone call, you might not be collecting that information, or they might be using those tools more often than they would if they were all working in the office together. So something else to keep in mind, you probably want to make sure you're preserving that information. And then, of course, try and stay on top of keeping your networks secure and your software to help protect against data collection and things like that from outside parties who aren't entitled to it are up to date, because new vulnerabilities are always being created and new protections against those are always just a step or two behind. So this last slide was kind of just looking at ways to talk about avoid spoliation. Now that people are working from home, it's a more succinct way of saying what I was trying to say. So that was a lot of information we threw at you in the past hour. I appreciate everyone's time. Either Angela or me, feel free to ask us any questions if you have any. And otherwise, thanks again. I'm glad we're able to get together, even if it was only virtually.
We do have one question in the chat box. I'm not sure if you guys can see that.
No.
I'm not sure if we
Yeah,
can.
I don't know if we can either. Oh, wait, actually.
Let me send it.
Okay, hold on. I think question. Wait, go that. Okay.
I see a question about the slides. We'll make sure everybody has a complete set of this whole presentation. And now we're reading another question.
Okay. Let's see. So this question relates to whether U.S. companies are affirmatively, if anyone's affirmatively requiring their employees to use the COVID tracking apps to help address infection risks at the company. I do not know if that is being required, at least to use the app that's been developed by Apple at this point. As I mentioned, there Ford was testing out a situation where they would use a device to just keep people 6 feet apart. So that's one way to do it. But actually, I see what you're saying. Actually, watching that to know if someone tests positive for COVID and sort of where they've been in the factory, that sort of thing. I wouldn't be surprised if we get to that point, but I do see some potential with the HIPAA violation as it relates as amongst your employees. So I think that's definitely something that a hurdle that would have to be gone through. I think it would be tough, especially in a situation where somebody can figure out who that employee is just because they only work with one other person. And then all of a sudden, hey, you were exposed to somebody at work. I only work next to Kevin, and so I know it's Kevin. So that would obviously be a risk. I think in a larger setting, there'd probably be a way to require people to get that extra screening just because someone in the vicinity was exposed. And I just know from what I have seen and heard from lots of different industries that companies are being very overly cautious. So if anyone basically in the whole building is being infected, I mean, unless you're in a completely separated area, they're going to require the extra screening anyway. So I think you could get away with it without exposing any HIPAA information. But
and I'll interrupt.
Yeah.
I'll add quickly, and this is just one example, anecdotal. I don't know if this organization is using any of the apps we discussed, but I'm representing a manufacturing client that is doing a very thorough job of tracking, and they have asked their employees to consent to that sort of information being shared. And that consent is a prerequisite for them being able to continue working right now. It's an organization where they have to work on site. I'm not sure, and so far it has not become an issue, how viable an argument to the effect of, you've required me to consent to something as a precondition for my working. I have to work, but I wouldn't consent if I wasn't in a financial position of having to work. How that might affect the effectiveness of the consent. But so far, I think that their employees have been willing to, participate in this, and the hope, of course, is that nobody will try and make the sort of argument that I just presented.
Yeah, well, I think that was the only question we had, other than the slides being available, which I believe that they will be made available to everyone. Just one other thing that we wanted to mention as it relates to discovery of cell phone data, wearable tech, some of those types of things. We have some experts that our firm has used over the past actually many years now with cell phones to be able to access data off of different hardware devices, that sort of thing. If anybody ever needs any recommendations for some outside consultants for that, we do have some names. There's some becoming more companies doing it, but there's some tried and true ones out there that we'd be happy to share with anyone who needs it.
And sorry to toss one more thing at you, but that prompted something I intended to mention. You should probably consider having your employees notify you if they're ever involved in a lawsuit where they've been asked to disclose data from their phones, because oftentimes data pulls from these hardware vendors or third-party apps or social media platforms, which may be less of a concern here, the social media, they can pull everything. Which would mean they would be able to pull not only the things unique to that individual that might be relevant to the lawsuit, but also things that are important to your business. And that would, give you a legitimate say in ensuring at least that part of the information wasn't discovered or was, protected through a proper confidentiality order or something like that. Helping identify what data is what is something that some of these forensic data people Angela mentioned can be a lot of help with. So kind of a big topic as an afterthought, but keep that in mind. Any other questions? Anything? All right. Well, thanks, everybody. Again, I really appreciate you letting us talk to you today.
Thank you. It's just like